Hello everyone and welcome to the Activist Lawyer podcast. My name is Sarah Henry and I'm your host to this podcast, which offers a platform for lawyers to share their story and their journey into law and activism. Our guests will discuss the challenges and highlights of their work, as well as important cases, opinions on legal and political matters, and will offer up advice and tips for anyone interested in pursuing a career in human rights law, public interest law, or criminal justice. The Activist Lawyer podcast is brought to you by the Granite Podcast Studio. Thank you so much for listening. Welcome to today's episode of the Activist Lawyer podcast. In the 1970s, when Louise O'Keeffe was just 8 years old, she was sexually abused by Louise O'Keeffe in Dundero National School, County Cork. Louise is now campaigning to get the same redress for her fellow classmates and in particular 19 women who have come forward. Louise O'Keeffe was convicted in 1998 and in court 21 girls gave evidence of sexual abuse. Louise O'Keeffe was given a 3-year jail sentence, having been charged with 386 counts of indecent assault, but pleading guilty to 21 sample charges. Recently, the Irish state refused to give 19 classmates of Louise O'Keeffe redress, which will force them into High Court litigation against the state. Why are these 19 women who were abused by the same abuser in the same school treated differently and not entitled to the same redress that Louise was? The government said they've commissioned a report which will be due in May 2027, but the state has been found liable for failing to protect Louise and her classmates from the appalling sexual abuse suffered by these women when they were children. It's now been over 55 years or 60 years in some of these cases where the abuse occurred, and 18 years since the criminal conviction, 12 years since the landmark judgement of the European Court of Human Rights in O'Keeffe. So how long will they have to wait? We are joined by Louise O'Keeffe, survivor and campaigner, and Professor Conor O'Mahony, Dean of Law with University College Cork. Thank you both for joining me.
Thanks very much, Sarah.
So, Louise, starting with yourself, and again, thank you for your work on this to date and for sharing and highlighting this issue. And many listeners will already be familiar with your name because of the landmark European Court of Human Rights case. But just before the legal battle, there was an 8-year-old child in a classroom in Dundero. And I'd like to maybe ask you, what do you want people to understand, I suppose, about the human impact of what happened and what led to the kind of legal battle that you took on?
I suppose primarily I want people to realise that it was a very innocent 8-year-old girl who was sexually abused by Louise O'Keeffe in Dundero National School. You know, when you think back to the 1970s, you know, 8-year-olds were extremely innocent and far more innocent than maybe a lot of 8-year-olds are today. And we neither had the words nor the phrases nor the ability to describe to anybody really what was happening. We didn't even know ourselves what was happening. And it was something that was extremely strange, extremely difficult. And at that time as well, I think people would have to remember the fact that, you know, he was the principal of the school, but he was actually known as the master. So, and the master had a lot of authority in a rural national school. It was a small 2-rooms national school. Generally speaking, at that time, if you went home and had said that you had gotten a slap from the master in school, generally speaking, you would have been nearly asked, what did you do? As opposed to, you know, why, or, you know, sort of a softer question in looking for an explanation. Generally, it was seen as you were at fault. So girls at that time were afraid to actually say anything, but also didn't have the words in being able to tell what had happened. In 1973, when it was discovered in the school, even at that time, you know, some of the girls had told their parents, yes, something had happened, but more of them, because of the fear of going into school the following morning and possibly facing Louise O'Keeffe, denied that anything had happened. And it was absolute fear that made them deny that. So really then I suppose, it sort of went from there and really sort of fast forwarded into the mid-90s, the 1990s, when one of the girls made a complaint to a Garda station, and then it was a case of entering the phase of investigation for the criminal case. During that time, I received a phone call and obviously knew what it was about. And I suppose because of the fact that I was one of the girls who had said yes back in 1973, I was still going to say yes, even though this was something that had never been spoken about in the interim. Yes, it went forward then to the criminal case and into court, where Louise O'Keeffe pleaded guilty, and he was a convicted abuser of young girls in school. At that time, I just felt when we came out of the court that, there was no assistance for any of the girls. There was nobody came forward from the Department of Education to give assistance, even though this had happened to very innocent young girls. And I really felt that this was something that could happen again today. Even though I was saying that in 1998, I would nearly still say it today. But anyway, it was a case of, I just felt that it wasn't right. There was no responsibility held by the department. Even, to be honest, I almost think that if they had given assistance to the girls that day in being able to seek counselling, because the majority of those girls had never been for counselling before that. So I decided to go to my solicitor and inquire about taking a civil case. And that's basically what we did. And it ended up being an extremely long road, in spite of serving legal proceedings in early September of 1998. It was 2004 before we got into the High Court. It was 2006 before we got judgments. It was 2009 before we went into the Supreme Court. Late 2009 when we got the judgment in the Supreme Court. That wasn't an easy time at all, because there was the length of time. Always in the background, there's always the fear of the fact. And I suppose in my case, it became fact in that I lost the case. I lost the case both in the High Court and in the Supreme Court, because of the costs that are involved in taking civil proceedings through the courts. Some people may ask, when I lost in the High Court, and with the fear of costs, why on earth would I appeal to the Supreme Court? But I still felt very strongly about the fact that the abuse that had happened to us as young girls in school wasn't acknowledged by the state. There was nothing put in place to protect us. There was nothing put in place to advise us with regard to counselling. And I still felt basically the same thing as when I had taken the case first, that if it happened today, this pupil would still be treated exactly the same as we were and as I was right through the civil courts.
An extremely long road. Well, it's been more than a decade since the judgment from the European Court of Human Rights, which of course ruled in your favour. When you look back after all that you'd been through with the court system here, what did that judgment mean for you personally, and what did you hope that it might achieve for other survivors?
On the date that the judgment came through, I felt that it was a good day for the children in Ireland, because I felt that here we have a European judgment that the state could not renege on. I felt that this was a positive thing for the past, the present and the future. I suppose personally, I didn't really sort of feel that there was a lot it would do for me, because personally what had happened to me could never be undone.
Sure. And
unfortunately, that's the same for every person who's been abused, whether they've been abused as a child or an adult. But I did feel that good would come out of it, in that it would mean that the state would then acknowledge the abuse that had happened in historical cases. I felt that that proaction would turn into positive for the future, but it has been extremely disappointing in the state's lack of implementation of the judgment. The fact that the European Court would actually rule that Louise O'Keeffe, who went to Dundera National School and who was abused by Leo Hickey, that my fellow schoolmates could actually been denied that acknowledgement. And that is it's extremely difficult. It is equally difficult to think that other cases in other schools are not acknowledged. But I suppose, it just really does highlight the lack of implementation by the state when they're refusing point blank to offer redress to fellow pupils of mine who went to the same school and were sexually abused by the same teacher.
Yeah, I mean, it's unbelievable and a real striking difference there. Before we get into the redress and the kind of history behind that and what we hope to happen, Conor, I'm just wondering, for listeners who might not be familiar with the case, could you maybe explain the significance of the European Court of Human Rights judgment and what exactly the state was found to have done wrong?
Yeah, absolutely. So the domestic proceedings had really taken the form of a personal injuries action. Essentially, it was suing the state as the employer of the teacher and arguing that the state had been vicariously liable for the teacher's actions in perpetrating what would have been the tort of assault. And so it really hinged on a vicarious liability argument. And the reason that it was unsuccessful in both the High Court and the Supreme Court was because they both ruled ultimately that because of the way education in the Irish system was structured, that actually the teacher was not employed by the state, even though his wages were paid by the state. So the schools, national schools, they're called national, which is a designation that implies that they are recognised by the state and funded by the state, but they're actually owned and managed by churches for the most part, certainly at that time almost entirely by the Catholic Church. So the teacher was found to be employed by the school manager, who would be the local parish priest, and not by the state. And so that mode of analysis left a situation where you had no state responsibility in this space. In spite of all the evidence that we had of extensive abuse having occurred in schools, lots and lots of children unfortunately experienced both physical and sexual abuse in Irish schools. And this interpretation by the Supreme Court ultimately created a situation where the state had no liability whatsoever in terms of its role. Because really, what we're looking at here is a situation where of course, individual abusers are at fault, but Louise's whole argument all along was that the fault could not be confined to the individual abusers, that the state had to have a role here. That if you have this going on such a scale for such a long time, and the state has done nothing to put it to an end, that the state surely has to carry some of the blame. So what the European Court of Human Rights judgment did really was it provided a new way of coming at the issue that allowed for more of a focus, first of all, on the rights of the children affected, and then secondly on the role of the state and the state's obligations to vindicate those rights. So it was based on two main arguments. One was an argument around Article 3 of the European Convention on Human Rights, which is the right to freedom from inhuman and degrading treatment. And that carries not only a negative obligation on the state to refrain from directly inflicting that sort of treatment on citizens, but also a positive obligation on the state to protect people from inhuman and degrading treatment at the hands of private actors. So on that angle, it meant that it didn't matter whether the teacher was employed by the state or not. You didn't have to prove that connection of employment in order to prove that the state had fallen down on its obligation. And so ultimately the court looked at it, and it went through an interesting survey of the evidence that existed through the middle part of the 20th century of the state's level of knowledge of how much risk was there in the primary school system that children would be abused, and looked in particular at a report from the 1930s called the Carrigan Report, and then the much more recent Ryan Report. And in looking at those reports, really said that the state knew at all material times that children in schools were at risk of being abused. There was evidence of abuse taking place, of complaints of abuse, of prosecutions of abuse. But in spite of knowing that risk existed in the system, the state took no steps to protect children against that risk of abuse. It simply handed over control of the whole primary school system essentially to private actors without putting in place any controls against the risk of abuse. And that was found by the court to fall short of its obligations under Article 3. And then the second part of the case was around Article 13 of the Convention, which is the right to an effective remedy. So once people's rights under the Convention are violated, there's a right to be provided with a remedy by the state for that. And of course, the fact that the state had fought and ultimately won its case against Louise in the Supreme Court left a situation where Louise or anybody else in the system couldn't receive a remedy for that rights violation. So there was a separate violation of Article 13 also.
And as Louise said, she wouldn't be sure if the same thing happened now, that a child would be adequately protected because of the state failing to, I suppose, implement the obligations that flowed from that judgment, which is a very significant and distinctive judgment, a very important judgment. So one of the key questions, Conor, is why are survivors who were abused by the same perpetrator, how can they receive different treatment under redress schemes? And maybe from a legal and from a human rights perspective, how difficult is it to justify that distinction?
Well, the very quick answer is that it's very hard to justify the distinction. But there's a much longer version of that answer because it's gone through so many iterations at this stage. I suppose as soon as the judgment was handed down, the state went into damage control mode to try and confine the Louise O'Keeffe case to its own facts and to try and limit its exposure to any other victims. So as I've just described it, the finding in the case, I think it's quite clear to anybody reading it that finding was a systemic finding. It wasn't a finding about something that happened specifically in Louise's case. It wasn't something specific to Dundero National School. It was a systemic finding that the state handed over control of the whole system and put in place no controls anywhere in the system. So therefore, on that basis, you would say that every child who was abused within that defective framework, whether in Dundero, certainly by the same teacher, is as clear cut as it gets. But equally in other schools under the same defective system, their rights were all violated in the same way and they should all be entitled to a remedy in the same way. But the state, of course, didn't want to countenance that level of exposure from day one. And so immediately, when Enda Kenny was a teacher at the time, he stood up in the Dáil to give an apology for what had happened in Louise's case. And the words he used was that he apologised to Louise for what happened to her in the place where she was. And that wording was an early indication of the direction of travel we were going to see. So the first thing that happened was there was a redress scheme set up to provide an avenue for out-of-court settlements for people who had been abused in the system. But the conditions were incredibly restrictive. There were a number of different conditions, but the main one that became the big focus of subsequent action was a condition that you could only receive redress if your abuse had occurred in the aftermath of a prior complaint that had not been acted on. Now, that was a kind of an incidental fact of Louise's case, that there had been a complaint made against Leo Hickey before Louise was abused. There was a line in the judgment of the European Court of Human Rights where the court noted, sort of in passing, if adequate action had been taken on that complaint, well, then perhaps Louise and others might not have been abused subsequently. But that was never the basis of the judgment in the O'Keeffe case. The basis of the judgment was, as I said earlier, the idea that control of the school system was handed over without any protective measures being put in place in that system, which is a different thing. So prior complaint as a grounds for redress, first of all, was a distortion of the basis of the O'Keeffe judgment. And secondly, it was completely impossible to prove. Because if you think about it in rational terms, how are you going to prove that a complaint had been made before you were abused? You would need to have evidence of that. And first of all, a lot of the social science evidence would indicate that the majority of children who were sexually abused while children don't disclose that fact until they become older. But then even if they have, and we know in this case there were so many people abused that there were some of them who did disclose, but then how do you prove that? Where do you get that evidence? So you're relying first of all on the religious orders having maintained records of that, which wouldn't necessarily have been in their interests. And secondly, even if they've maintained those records, you're relying on them handing them over. And the ex gratia scheme provided no mechanism to compel them to hand them over. So why would they hand them over? Because they're then exposing themselves as well. The upshot of all of that was that scheme ran for a few years, and every single application to it was rejected. It was designed from day one to prevent people from getting redress. And of course, in that process, just compounded trauma and hurt and upset for people who, having been abused in that defective system many years ago, when they then come seeking the remedy to which they're now entitled, they are now put through the ringer and turned away once again. So that led to a lot of back and forth. There was a retired High Court judge, Iarla O'Neill, who was appointed to review. There was an appeals mechanism under the scheme, and he was appointed to review the appeals. And I think when he saw this pattern of every single application being rejected, he thought that this isn't right. So he took it upon himself to review whether the scheme itself and its conditions were compatible with the O'Keeffe judgment. And so that then led to some back and forth. He saw submissions on that point from the Irish Human Rights and Equality Commission, from the Child Law Clinic in UCC, because we had been involved with the previous Strasbourg proceedings in Louise's case. And after quite a bit of back and forth with submissions in return from the Attorney General's office, in 2019, Judge Iarla O'Neill ruled that ex gratia scheme was not compatible with the O'Keeffe judgment. So that was a positive finding, vindicated what we had been saying all along, which was that scheme had been designed to shut down liability and was never in line with either the letter or the spirit of the O'Keeffe judgment. Following that, it then took the government 2 more years to design a replacement scheme. Now, that in itself was an extraordinary delay, because really all you had to do was take out the condition of prior complaint. There wasn't much more needed than that. So the replacement that opened up in 2021 was certainly less restrictive and has now seen, over 100 survivors receive payments on foot of the abuse they experienced in the school system at that time. But it nevertheless still contained restrictive conditions, in particular a requirement that somebody could only be compensated if they had previously taken litigation against the state prior to July of 2021. The deadline, in fact, was set 2 days before the scheme itself was announced. So nobody could adjust their position once the scheme was announced. Of course, a lot of people hadn't litigated against the state, often for very good reason, because in domestic law terms they couldn't win because of the Supreme Court judgment in Louise's case, and the European Court of Human Rights decision, of course, is a matter of international law rather than domestic law, and wouldn't change that position in the Irish courts. So you're requiring people to take litigation that they couldn't win. Also, people had been waiting to see what would happen with the ex gratia scheme quite reasonably, because at this stage we had multiple apologies. I think after the 2019 decision from Iarla O'Neill, Leo Varadkar was Taoiseach at this stage, and he stood up in the Dáil and he said, we failed the survivors when they were abused. We failed them again with this scheme. We will not fail them a third time. And so, of course, people were waiting to see what would happen. But this latest version of the schemes, in spite of being an improvement and having now seen numerous people receive their remedy, we see quite a lot of other people who hadn't previously litigated against the state still frozen out of that. And there's no reason for that other than to limit the scope of liability, because it's not anchored in anything in the O'Keeffe judgment. There's nothing in that judgment that you can hang it on. It's not, nor is it anchored in the statute of limitations, because if it was, it would have been phrased completely differently. So it has departed from all of the legal norms, as it were. It's really in there for one reason and one reason only, and that's to limit the number of people who can receive a payment.
Gosh, how tough, as you've mentioned, for anybody who's been through this and have to go through this system of delays. And I'm wondering then about this report that they've commissioned for May next year. What's the significance of that? Is that just another attempt to kind of delay matters, or what do you think about that?
Well, so what has now happened, I suppose, is that last version of the ex gratia scheme that I described, that was open for 2 years. So people had a 2-year window within which they could put in their applications. So that has now run its course, and that scheme is closed. And so I suppose we'd reached a point where people who worked on this issue, like the team in the Human Rights and Equality Commission or myself, who've been advocating in this space, we were starting to look around and think, right, it's getting hard to make further forward progress on this, and the options are narrowing all the time. And then what happened, I suppose, that has shifted the needle somewhat, was the Blackrock Boys documentary on RT Radio, which it led to further revelations of more abuse that had happened in Irish schools. That led to the scoping inquiry, which was subsequently published, which made a recommendation that there should be a commission of investigation into abuse in schools, and also that there should be redress. So on foot of that scoping inquiry, we now have yet further commitments from government. The Commission of Investigation has been set up, so that is going to be running its course. There was also commitments made by senior government figures to redress coming back onto the table, and that would mean that people who've been excluded from previous versions of redress schemes would now be hoping that maybe there'll be something that will come along that will be more flexible and provide a more fulsome and holistic approach, and that people who've been excluded in the past will actually be included. The difficulty with that is that in an ideal world that would happen in parallel to the Commission of Investigation. You wouldn't need to wait until the report from the Commission before you would start providing redress, because of course commissions can take a very long time, as we have seen repeatedly. And we're dealing with people here who, have been waiting an awfully long time already. Some of them are ill health or advanced years and so on. And making people wait another, maybe 5 years for something to which they have clearly been entitled since the judgment in O'Keeffe in 2014 is unconscionable, really. But that appears to be the approach right now, as to, certainly whether it will have to wait until the very end of the commission process or at some other point in between now and then remains to be seen. But essentially, there doesn't seem to be any particular rush in progressing to a point where there's a clear redress scheme open with clear terms and conditions that where everybody knows where they stand. It's all at a kind of ill-defined future point at the moment. So there's just a lot of uncertainty, on top of everything else that's happened over the years.
Conor, and is there any reason to wait for a report that's being commissioned for redress?
There isn't. And the reason I say that very simply is because since the O'Keeffe judgment in 2014, we have already been providing redress to other survivors of sexual abuse in school. So it's well over 100 people, I think maybe over 150 at this stage, who either through the ex gratia scheme, the second version of it, which did start compensating people, or alternatively through a number of people who've received out-of-court settlements. So the state has already provided compensation to a certain number of the victims. Of course, there are others who have been left behind, as we've already outlined. But any argument to say that you can't move ahead with compensating people until a commission of investigation or some other body has completed a further report on this doesn't hold water, for the very simple reason that we've already been doing it to a certain extent, and so therefore there's no reason why we cannot continue doing that and devise a framework which can move ahead and move towards adequate implementation of the O'Keeffe judgment without any further delay.
Thank you so much, Conor. Yeah, I think they're important just to clarify those pieces. So Conor, in your opinion, and I suppose from a legal perspective, what would the proper implementation of O'Keeffe look like?
I think it's very simple, really, Sarah. Because the finding was systemic, and because the finding of the case applied equally to any children who experienced sexual abuse in that defective framework that existed at that time, adequate implementation of the judgment would be that compensation should be made available to every child who experienced sexual abuse in the primary school system or indeed the secondary school system, up to the point at which an improved system of child protection was introduced in the early 1990s, and that should be without any question of forcing people to go through expensive court proceedings. It should be without questions of whether or not they had previously litigated against the state. If children experienced abuse in that system, then their rights were violated in the same way, and they should all receive the same redress. And
I'm also thinking about, we're talking here about a historical kind of review of cases in terms of the redress scheme, but I know it's your area of expertise. What's the current state of protection like in this? Have things improved drastically, or what are we looking at today in terms of protection for children who suffered abuse?
Fortunately, things have moved on quite a lot. It's taken a long time. We were slow to come to the table on this, but from originally the introduction of guidelines in the early 1990s through to a series of binding legal measures which have come in place since then. So we now have things like, for example, mandatory reporting legislation. So one of the difficulties which arose historically was the fact that where complaints were made, those complaints were not passed to any state authorities, so that the Department of Education or the Gardaí or anybody else simply didn't know that a complaint had been made to the school because the school never passed that information on. We now have legislation which would require those reports to be made, so that's certainly quite different. We also have legislation like the Garda Vetting Framework, which now provides a framework whereby if somebody is to work as a school teacher or any other job indeed in the school system where they will have contact with children, they'll have to go through a Garda vetting procedure, which allows you to provide some background check as to whether or not that person has any track record that might suggest that they pose a potential risk to children, and makes it less likely that they would be employed in those roles in the first place. Now, that's not to say that all of those systems are foolproof in any respect, but certainly there's an awful lot more there by way of child protection law and policy than would have been the case in the 1970s.
And Louise, when you hear Conor talking there and just outlining, I suppose, the legal arguments and the legal history behind all of this, do you feel or have you felt that the lived experience of the survivors of this type of abuse has centred at all in the development of this, either through the case law or through the government's response? And how should survivors be reflected in the decision-making process around a redress scheme and around decisions relating to it?
Oh, certainly I don't believe that the state has taken into consideration at all the result on people themselves of the sexual abuse in the schools, because they're ignoring them. It has always been well known that the abuse in Dundero School, that the conviction of Hickey was on 21 girls, and that is known since 1998. It has been raised several times throughout my case that I was not the only girl, that there were a further 20 girls. And it's just unbelievable, really, that the state can turn around and ignore and refuse those girls any sort of acknowledgement by way of redress. And even, it's certainly not something that can be ignored. Mm-hmm. And I must point out in the sense as well that back in 1998, when we were in the criminal court, Micheál Martin was Minister for Education at that time. He's now the Taoiseach. And quite honestly, the way I felt when I left the court that day, in the sense that we were ignored, they didn't want to know about us. They really wanted us brushed out of the way, is the exact same way today with Micheál Martin as Taoiseach.
Mm-hmm, yeah. And I guess Conor has already touched, I suppose, on that kind of the prolonged delay and the impact that has on, even from a human rights perspective, on people, particularly where survivors have spent so long, decades waiting for recognition or something to come out of this. But I'm wondering, just finally, thinking about what you've been through, Louise, yourself, what has kept you going and, not campaigning just for yourself, but for others through all of this? And how does justice look like for you and the other women that you're representing and working with?
Well, I've always had the support of the Dundero girls throughout my campaign. And, the fact that 21 of us would sit in criminal court, you certainly don't walk out of that and forget any single one of the others. The fact that you don't meet every day doesn't remove that connection, I suppose is a word that you use, in binding you together. It's because of the fact that you have all experienced this awful trauma that, quite honestly, it's only other victims can actually understand. And it is because of that you just can't walk away until something is really done correctly. The European judgment was hard fought for. And after fighting that hard to get that judgment, it has to be implemented. So for all that I have been fighting for it, others have been waiting. And that waiting does wear people down. And it's just it's just not right. It's not treating a fellow human being the way they should be treated. And if our state and our government departments are treating the people in Ireland like that, they should be ashamed. They should be really and truly looking after the human side of people. Ireland are noted for their human rights arguments abroad. Ireland are looking for the human rights seat in the UN. To me, how on earth can they look for that seat when they're refusing to implement the judgment from the European Court of Human Rights?
Yeah. Louise, we're profoundly grateful for you, for your work, for the campaign and for all that you've done to make change. And I'm hoping that you and the survivors, with the help of anybody that's involved in your campaign, see that change and see that shift in society and in the government, who must follow through with their obligations under that judgment. Louise O'Keeffe and Conor O'Mahony, thank you so much for joining me today. It's been a pleasure to speak to you both.
Thank you very much.
Thanks, Sarah.
Thanks everyone for joining me today. If you like the show, please remember to share and leave a review if you have a moment. And you can also check out our website, www.activistlawyer.com, where you will see some blog articles written by our guests and contributors, as well as some fabulous Activist Lawyer merchandise.
This podcast was recorded in Granite Podcast Studio. Interested in starting up your own podcast but don't know how? Granite Podcast Studio can help. Record your podcast in our state-of-the-art studio, which is based in the heart of Newry City. Our studio has cutting-edge and user-friendly technology and can seat up to 4 people. We also provide an editing service for our team, using your guidance and editing notes to provide you with a flawless finished product, leaving your listeners wanting more. For more information on how you can get started, visit www.granitepodcaststudio.com.